Hi, everybody. We're just going to let everybody filter in. We do have a pretty solid list of attendees signed up, which is fantastic. And we're really looking forward to having you here to hear our one of our favorite speakers, Keith Masterman, speak about powers of attorney and estate planning. So thank you. It'll take a couple of minutes for everybody to get on, but as we do, I'll just stall for time here. In the meantime, what I'll do is I'll start by introducing our team, and then we'll introduce Keith, and then hopefully by that time we'll have a solid amount of the people that are supposed to join on here. So from left to right, in no particular order, well, in somewhat particular order, on the left we have Jeff Wachman, who is the founder of our team, and he's been at this for quite some time. We won't quite mention how long that is. But Jeff has been with Asante and his predecessor companies for quite some time and has a ton of experience in financial planning, investments, insurance, and everything that you need to have a successful life. Myself, I've been working with the team now for a number of years. We have Erik, who joined us a few years ago as well, and has brought a lot of energy and vigor and expertise to the team. And then we have really the nuts and bolts, or the nucleus of the team, which is Ose and Leah, who keep the lights on and make sure that clients are happy, and that is key. So that's our team. If please feel free to reach out to any of us if you have any questions or anything you need. Today we're very lucky to have Keith Masterman speak with us from CI Global Asset Management. Thank you, Keith. Keith has spoken with us before, and he's done a great job every single time. So hopefully some of you have enjoyed Keith's presentations. I know I always enjoy his expertise, but most particularly I enjoy Keith's humor, and I told him that privately as well, so it's actually true. There's a whole bunch of stuff here about why Keith is expert on this area, but I think really, you can read that on your own, but really you just need to trust us to know that Keith is an expert in the estate planning area, and he is a fantastic speaker. So Keith, I'm going to stop sharing my screen. We will come back later and just tell you about our upcoming events. We'll also tell you about, we'll also take any of your questions. People, what I really would love is if you do have questions as we go along, fire them into the chat, raise your hand, or put them in the Q&A section. Erik and I will try to monitor that and monitor any questions that you have. And before we go to Keith, I think, Jeff, you wanted to just say a few words of welcome. So I'll throw it over to you, Jeff.
Thanks, Per, and thanks, Keith, for being here for our clients. It feels, for those of you old enough to remember Romper Room, I feel like I see clients.
Oh, Jeff, you muted yourself. Jeff, you let me see if I can unmute Jeff. Jeff has muted himself.
Okay, I'm unmuted. Anyway, I see
you're telling us your joke about Romper Room.
Yes, and David and a few other familiar names, arenas out there. So thank you for attending. I know it's a topical subject. We're not getting any younger, and it's an important issue. As a matter of fact, I just finished a course I had to take for my Quebec licensing, and they devoted an entire section to powers of attorney. And the laws in Quebec are a little different, being kind of the civil law Napoleonic code, and their determination of when a power of attorney comes into effect is a little clearer than it is, I think, in Ontario and other parts, in the common law parts of the country. So hopefully Keith can shed some light on how we have to structure these documents to make sure that they're enacted only when necessary or when needed, and when they are actually needed, that they're enacted without undue delay. So that's all I have to add. And again, thanks for being here, and I look forward to hearing from Keith as much as everybody, I think.
Great. Well, I guess it's over to me then. Let me see if I can share my screen. I hope that did it. There you go. Hopefully that shared my screen. I don't see Good. There was a thumbs up. I don't see anyone aghast who's
Oh,
a
yeah.
host of
Oh,
this
that's
thing
good.
looking just awful. So there we go. Perfect. Well, that was very interesting, Jeff, that you talked about how they had an entire session on powers of attorney. And I think that's just thrilling because, in fact, it's my second thrill so far in the presentation. The first thrill was to see that I was wearing a different jacket than in the picture you put up of me. I'm always worried about, oh my God, is it the same jacket? Then I only look like I only own the one, but I have two. So there you go. But the other thing was to hear that they're taking powers of attorney so seriously. Because really, when you think of it, a power of attorney is such an incredibly important document. And that's why I wanted to talk to you about it today. And I think I really want to get through 3 points at the very start. First of all, I think a lot of people treat a power of attorney as an afterthought. You'll spend an awful lot of time with your advisor and with your lawyer talking about your will and making sure your will is tax efficient and making sure your will does this and that and meets all sorts of contingency. And then at the end of the meeting, your lawyer will say, oh, you should also have a personal care and a financial care power of attorney. And it's almost treated as if it's a pre-printed form. And way too often it is treated that way and presented that way. And I think that's a real shame. And I think it's a shame for 2 reasons. One, powers of attorney rip families apart. Years and years ago, when I was young and charming, I was involved with this case where a gentleman came in and he said to me that he was the power of attorney for his mother who had just died. And they wanted me to go through all the documentation from his power of attorney, all his accounts and everything, and provide an opinion about whether he did anything wrong, sort of a forensic analysis. And the gentleman talked to me for a little while, and he mentioned that his mom's funeral was Thursday at 2 o'clock or something like that. In the afternoon, his sister came in to talk to me about some of her concerns about her brother being power of attorney. And she mentioned that the mother's funeral was Friday at 2 o'clock. And I said, no, it's Thursday at 2. And she said, no, my brother and I, there's so much suspicion about what he did as power of attorney that we won't be in the same room. So my mother's going to have 2 identical funerals, one on Thursday and one on Friday. And to me, that shows the power of a power of attorney, or the downside of a power of attorney. You really have to be careful to make sure your power of attorney knows what he's doing and understands his duties. And then the other reason I want to talk to you about them, where I think they're so important, is they affect you for a heck of a lot longer than your will does. I think the average Canadian lives till about 87, 86, somewhere in that range. I'm sure Eric and Per and Jeff can tell us, but it's some age like that. So your power of attorney probably will affect your life for many, many years at the end of your life. Your executor, on the other hand, in your will, you know what? You'll be dead, so you won't be able to see your family rip each other to shreds, and it's going to affect your estate for 2 or 3 years, whereas your power of attorney could go on for years and years and years. So it's really incumbent to have the proper person's power of attorney. So what are we going to talk about today? Well, I've broken my topic into 6 different categories to consider. The first ones, I think, are things to think about before you enter a power of attorney. So these are before you actually put your signature on the document. And those are, first of all, understanding the types of powers of attorney. And some of the things Jeff was talking about, we'll talk about during that period. There are as many as 6 different types of power of attorneys. Today, we're only going to talk about 2, being the financial and personal care power of attorney. The second thing is who to name as power of attorney and who you might not want to name as your power of attorney. And I'll give you a little bit of a spoiler alert or whatever they call those things. My son is my financial care power of attorney. My daughter's my provincial care power of attorney. And for a whole bunch of reasons, which I'm going to bore you with in a few minutes, we chose not to name each other, my wife and I. We're not named as power of attorney. And there's a whole bunch of reasons why, and we'll talk about that there. Then we're going to talk about limitations in your power of attorney. Your power of attorney can only do what's in the Substitute Decisions Act, the Trustee Act to a certain degree, and what's in the document. So it's important that you consider what you want them to do and put those in the document. And that's the main reason why I think the pre-printed form that's half a page long is really a big mistake, because it's robbing you from a whole bunch of opportunities to put other things in the power of attorney that could be important. The second group we're going to talk about is, I think, things to talk to your powers of attorney about. Things to talk to your son, your daughter, your wife, whoever you're naming as your power of attorney. And that includes the duties of a power of attorney. What is your loved one getting into by agreeing to act? And making sure they understand those powers of attorney so you don't end up with 2 funerals. Secondly, the liability. What are you putting on your power of attorney's shoulders? This stuff has serious civil and criminal liability attached to it. And lastly, compensation. How much can your power of attorney be paid for what they're going to do? So let's start with understanding the types of power of attorney. But what I really want to talk about before I disclose the next slide is what happens if you don't have a power of attorney. So let's say you don't have a power of attorney and you become incompetent and you can't manage your own financial affairs. Well, someone in your family is going to have to apply to court to be named a guardian of the person or a guardian of the finances of you. Years and years ago, back when I was practicing law, I was involved in a case where a woman and a man did not have powers of attorney. And why would they? They were both a very young couple. I think they had children who I think were 4 and 2 years old, if I remember correctly. And they lived hand to mouth. 1 week he would get paid and they would, put it towards rent. And the next week she would get paid and they put it towards food. And that's how they lived. So what reason did they have needing all these powers of attorney? They both worked assembly line jobs. And she went to her job and someone played a practical joke on her, which wasn't particularly funny or practical as it turned out. And a piece of heavy equipment hit her right there on the back of the head. She was left in a comatose state, and that's how she remained for many, many years afterwards. Suddenly, they changed from being a couple with very few assets to being a couple where she had settlement and insurance payments coming in, and he had very few assets. But he wanted to manage the money on behalf of his wife to provide for her and to provide for his boys. But of course, he didn't have a power of attorney. So we had to bring a guardianship application, name him as the guardian of her person. And it really hit home for a couple things. One, Franklin Delano Roosevelt said the problem with people is they eat in the short run and we plan in the long run. Powers of attorney are available immediately. Whereas if you're going to get a guardianship application, it's going to take time. Everyone who has an interest in your estate has to be served. You have to have at least 2 doctors testify that you do not have capacity. They can testify in an affidavit form, but they have to testify. You have to have a financial advisor provide a description of how you will invest the person's money. And that became a lot more complicated 2 years ago because of an Ottawa decision, by the way. A lot more complicated for financial advisors. So you have to have all of this stuff. So it takes a while to put it together. So if you don't have a power of attorney, you're going to cause delay in getting the care you need. And you're also going to put your family through potential hardship in bringing that application and determining who's going to be the proper person to do it. There's also no guarantee that you'll be successful. Your loved one could make that application and the court could refuse. The court will refuse if they feel that you have a conflict of interest. They'll refuse if they feel the financial plan is not adequate and not provides properly. So there are grounds for refusal. But let's move on to powers of attorney. So the first type of power of attorney I want to talk about is financial care power of attorney. And what is a power of attorney? Well, a power of attorney is simply a document authorizing someone else to make decisions on your behalf. And in the case of financial care power of attorney, it's authorizing someone to make financial decisions on your behalf. In Ontario, we recognize 2 types of financial care powers of attorney: a general power of attorney and a continuing power of attorney. In Ontario, every single financial care power of attorney is deemed to be a general power of attorney unless it says somewhere on it that it is a continuing or an enduring power of attorney. If it doesn't have that language, it is a general power of attorney. Who cares? Well, you will if something happens to you. Because a general power of attorney ceases to be effective if you lose capacity, whereas a continuing or enduring power of attorney continues into capacity. I can't tell you the number of times advisors have had a power of attorney in their file, their client has lost capacity, they've sent it into their head office, and their head office has said, it's void, it's of no force and effect. And the reason is because they're using an old precedent or using a precedent that has a general power of attorney instead of a continuing power of attorney. So you might well want to just make sure when you enter a power of attorney, it's a continuing power of attorney. Jeff was talking about when does a power of attorney become effective? It's sort of a catch-22 because a power of attorney becomes effective the moment it's signed. So if I name my son, my daughter, my cousin as my power of attorney, they could take that power of attorney and begin to act on my behalf tomorrow. And a lot of people say, well, that's not really what I want. I want to hold on to my affairs and know that I'm the only one managing my affairs. I like my kid, but I don't trust him that incredibly far. And so therefore, you might want to consider, if that's how you feel, putting a triggering event in your power of attorney. You can limit when a power of attorney becomes effective by simply putting in the document, this power of attorney will only become effective if, and then whatever condition you might want. You might want it as a condition that you're declared unable to manage your financial affairs. You might want it as a condition that you are incompetent. You might want some sort of condition in it. And the conditions which are right for you are completely personal to you. The problem with putting a triggering event or a condition in your power of attorney is, how do you know when that triggering event has occurred? And so therefore, if you're going to put a triggering event in your power of attorney, because you don't want power of attorney to become effective immediately, you're going to have to put a clause in to say, how are we going to know the triggering event has occurred? Is it going to be something like, my family doctor provides a note saying I'm unable to manage my financial affairs, or I direct you in writing? What if you don't have that condition? What if you simply have a triggering event that says, my power of attorney becomes effective if I'm unable to manage my financial affairs, but you don't have a way of cocking the trigger, so to speak, on the condition? Well, in Ontario, Section 9 of the Substitute Decisions Act says your power of attorney will only become effective if one of two things happens. The first is that you are assessed by a certified assessor in Ontario. So that means you have to go through the formal process of an assessor meeting with you and assessing your capacity and declaring you unable to manage your financial affairs. And you want to know something? You will refuse to do it. Assessments are completely voluntary in the province of Ontario, and you will refuse. Even if today you say, of course I'll go through the assessment, but you will refuse. You'll be going through a period in your life when you're beginning to get a little paranoid, your capacity has certainly slipped, and you're becoming more suspicious. Those are some of the signs of incapacity. And you're going to suddenly have an assessor knock on your door, and he or she is going to sit down and say, your children or your spouse or whoever had some questions about what you can and can't do, and they're here to assess it. And you'll kick them out of your house because of that paranoia. You'll then phone your advisor and you'll say, someone from the government tried to steal my money today. And that's the problem with assessments. I've talked to assessor after assessor and said, here's the script. So if you refuse to get an assessment, which is completely voluntary, the only way that power of attorney will become effective is if a certificate under the Mental Health Act is issued. A certificate under the Mental Health Act is involuntary. It's not a nice process. And you will likely end up being institutionalized at the end of it. And it's not a very nice way of passing on powers to someone else. So really make sure that you understand the difference between general and continuing power of attorneys. You think about whether you want a triggering event. And if you do, how are you going to make that triggering event occur? What are you going to put in there? Because otherwise you're left in a bit of a mess. The last point I have down there is cross-border planning will likely require more than one power of attorney. If you're a snowbird and anxious to get back to the drive back and forth from Florida or wherever you might want to spend your time, make sure you think about whether you need a power of attorney in other jurisdictions, because not a power of attorney is provincially regulated, and not all powers of attorney are recognized everywhere. For instance, let's say you have a condo in Florida and you have a bank account in Florida and you lose capacity down there and someone needs to manage your affairs down there for you. A Florida power of attorney is only recognized as valid if it has the sentence in it that says, this power of attorney is not affected by subsequent incapacity of the principal except as provided by section 708.08 of the Florida statute. There's not a power of attorney drafted in Ontario that will have that clause in it. So if you have all your documents done here, you run the risk of having a real issue down in the States. That became a really big issue for my family some years ago because my father and his wife were down in Arizona where they lived for 6 months out of the year. And that's exactly what happened. He fell and hit his head, and he was in a state where for a couple of weeks he was unable to manage his affairs. His poor wife was running around with his powers of attorney, personal and financial care, that were drafted in Canada. And of course, they weren't recognized anywhere. And what a horrible time to discover that. So do make sure of that if you have cross-border issues. The other type of power of attorney I want to just mention, and we're not going to concentrate on all these are a lot, is a personal care power of attorney. And a personal care power of attorney is a document that authorizes someone else to make decisions on your behalf. And the only things they can do, you'll see it in bullet 2, are make healthcare decisions, nutrition, shelter, clothing, hygiene, and safety decisions, nothing more. So that's what they can do. You will also notice that we've distinguished between a personal care power of attorney and an advance directive. An advance directive is a longer document that sets out the type of care you think you need in certain instances. There was a great tool that was issued by the University of Toronto's bioethics department years ago. You won't be able to find it too easily, and if you can't find it, I can send you guys a copy of it. But it sets out a whole bunch of things to think about when you're putting a power of attorney in place, a personal care power of attorney. And it goes through things like, what happens if you have a minor stroke? What's the care you want? Well, what if the stroke isn't so minor? What if it's catastrophic and you can't communicate? Do you want to be moved to a home to start saving money for your wife and children, or your husband and children? Or do you want them to spend every nickel you have keeping you in that house? So it goes through all of those, and it's a great planning tool for putting a personal care power of attorney and a directive in place. It's also a great thing for communication purposes, because like almost everything else I talk to you guys about, I think one of the big issues with powers of attorney is make sure you communicate with your family about what it is you want. There's nothing worse than putting the right documents in place, but having no idea of what you want. And I'm going to give you an example, and it involves Mrs. Friedberg. Mrs. Friedberg was an 86-year-old woman. She lived in Toronto, Ontario, and for a few months every year, she lived down in Florida. She lived in Miami area. While in Florida one year, she had a cardiac arrest, and it left her with severe brain damage. She was really comatose for all intents and purposes. After a short period of time, they were able to airlift her back to Toronto, and she was put in the Baycrest Center here in Toronto. Her doctor, Dr. Korn, who was looking after her, had a copy of her power of attorney that named her 3 daughters as powers of attorney. He called the daughters in and he said, you know what? I am recommending we remove your mother from life support. She has no chance of a quality of life, and that's my recommendation. Dr. Korn also said, if you read her power of attorney, here it is, there's a clause in it that says that please do not use any heroic means to extend my life. In other words, if you're in this position, unplug me. The daughters were left in a horrible position. They didn't even know they were powers of attorney until that morning. And now suddenly they were asked to unplug a life support that would kill their mother. They talked it over and they went back to Dr. Korn and said, with all due respect, we can't give you those instructions. We want her to remain on life support. And their issue was this. They said, we don't believe she had any clue about that clause in her power of attorney because we're Orthodox Jews. And this is so contrary to our religious beliefs. And our mother lived according to those tenets every day of her life. And there was no way she would ever agree to this. Well, Dr. Korn doesn't have to accept, no doctor has to accept what you say. He can take the matter to the Medical Consent Capacity Board, which is a board that reviews decisions received from families. And that's exactly what Dr. Korn did. And the board looked at a whole bunch of things. They called the lawyer in and asked the lawyer, can you go through what happened when this power of attorney was executed? And the lawyer said, well, you know, I don't really remember Mrs. Friedberg. I don't have many notes and records of my conversation with her. I put that clause about life support in every power of attorney I draft, because let's face it, 98% of us want that clause. But I can't tell you whether Mrs. Korn actually instructed me to put that clause in there. I do usually read the power of attorneys over to people, and I suspect I read it over to Mrs. Friedberg. Based on that, the consent board said, we believe Mrs. Friedberg knew exactly what that clause said. We believe she consented to it, and those are her instructions, and so they overturned the daughter's recommendations. The daughters took the case to the Court of Appeal, or to court for an appeal, I should say. And the Court of Appeal looked at it and said, no, we don't believe she had capacity. No, we don't believe she understood that clause was in there. And therefore, the instructions from the powers of attorney are sanctimony, and they can give you whatever instructions they want. And Mrs. Friedberg remained on life support. But think of all the ways that was wrong, because they didn't have that conversation. They didn't have that conversation about what do you want. They didn't go through that article and say, what is it our mother wants and doesn't want? Not only did a whole bunch of heartache happen to that family, but a lot of expense. You know, these boards are not come cheap. So there was a lot of expense associated with it too. What I'd like to talk to you about for a few minutes is who to name and not name as power of attorney. And as I said to you before, I'm going to concentrate on a couple things in particular. One of them is, I'm going to tell you why my wife and I haven't named ourselves as power of attorney. And I'm also going to talk a little bit about cross-border again, coming back to that issue of people who live in different jurisdictions. Because as you know, people move around an awful lot. You know, I think last time I talked to this group, I think I used the statistic that 25% of seniors do not live within 400 kilometers of their children anymore. Kids move all the time. So it could well be that you end up having kids or whoever you think is your power of attorney in different jurisdictions. So that's the two things we're going to talk about for you. First of all, powers of attorney, you can have as many as you want. You can have an individual, you can name a trust company as your power of attorney. Trust company is a very good idea if you have no one else, or if you foresee there's going to be huge fights within your family. You can have more than one individual. You could have a member of your family and a trust company. So the permutations are up to you. Really, other than that, as long as they are over 18 years old and competent, you can name a person as a power of attorney. So let's talk about the two situations I wanted to talk about. Why is it that I think when you're my age, I'm a trailing baby boomer, and a guy looking forward to retirement in a few years, so that gives you a hint about how old I am. Why is it that I might not want to name my wife as power of attorney? And the reason is this. There's an awful lot of literature around the fact that when I lose my capacity, I will probably be about 84, 85 years old. That's what statistically shows that is the point at which I will not be able to manage my affairs anymore. Well, if Per there is my power of attorney or my advisor, and my wife comes in and says, here's his power of attorney, I'm going to start acting for her, chances are really good she's going through the same decline I am because we're about the same age. She's a few years older than me, in fact. So chances are my attorney will not be able to mentally act on my behalf because I've named someone who's exactly my age. The other issue, of course, is I've named someone who will be more personally affected by my incapacity than anyone else. She will be getting used to living more or less on her own. She'll be making horrible decisions about what to do with me from a nursing home point of view and all sorts of points of view. What a horrible, horrible thing to put on someone at that point in their life. And so therefore, an awful lot of people are saying, maybe the powers of attorney for each other are not a great idea. Maybe I should skip down a generation and start talking to the kids about acting as power of attorneys because they'll be in a better position to do so. The other thing I wanted to mention to you was whether or not you should name a Canadian as a power of attorney. When we talked about trust law in one of these sessions, we talked about the fact that the jurisdiction of a trust, so for your estate, in other words, after you pass away, is where dominant management control of the estate resided. So if I named a non-Canadian as trustee of a trust, someone in the United States, for instance, or as my executor of my estate, IRS would take the position that that trust is now an American trust because dominant management control, the guy who makes all the decisions, lives in the United States. That's not true with powers of attorney. A power of attorney is an agency matter. It's not a trust matter. So therefore, I can name someone in the United States, Britain, it doesn't matter where my power of attorney resides. They can still act as my power of attorney and it will not affect my tax jurisdiction. Phew. But there's a problem. And that problem is that my power of attorney, so let's use my case of my son, Jack, will fly up here to Stratford or go to Toronto and he'll say to Jeff, hey, Jeff, I'm Dad's power of attorney. And Jeff will say, well, we need some documents from you because that's what our due diligence thing says. And they'll look at it and they'll say, here's a problem. You're an American. I can't take instructions from you. So the whole purpose of putting the power of attorney in place, and there's nothing in law that says I can't, is completely defeated because what I want him to do is manage my finances. And because of regulations by the regulators who regulate investment advisors, they won't be able to provide those instructions. So what's the solution? Well, a lot of people are saying, I want my son to be my power of attorney, but I realize I don't know where he's going to live by the time I become incapacitated. So they're adding a clause into their power of attorney that says, my power of attorney may, by simple deed, transfer the duties to someone else. In other words, can resign and name someone else. If that clause isn't there, that individual is going to have to go to court to name a new power of attorney or a guardian. But they're putting a clause in that says, if for any reason whatsoever, it does not appear to be beneficial for me to act as my father's power of attorney, for my son to act as my power of attorney, it's in my document, I hereby grant my power of attorney the authority to name someone else. So when they meet with Jeff, Jeff can say, well, you can't really give us instructions. And my son can say, well, my sister lives just 3 doors down. and they'll be able to solve the problem that way. When we're talking about investment counselors, I also wanted to mention one other thing that really doesn't fit in here, but what the heck. And that is that an awful lot of people are now recommending that you put a clause in your power of attorney authorizing your power of attorney to retain a financial consultant and investment counselor. There was an opinion that came out about 3 years ago now that said that unless your power of attorney document does not contain that power, your power of attorney does not have the right to hire a financial advisor. So what does that mean? Well, it means that if I've been acting with Erik for 20 years and I become incapacitated, my power of attorney can continue to act on with him. He can continue to retain Erik, and Erik can continue to give me advice. But if I don't have a power of attorney, a financial advisor, or if my financial advisor can't help for whatever reason, my son will be unable to hire Erik without that clause in it. And the reason is because a power of attorney is an agent, and an agent can't subdelegate. And when you hire an investment consultant, you're subdelegating. You can't do that without authority. So it's really important to think about whether that should be in your power of attorney as well. I wanted to talk to you for a few minutes, and I realize that I have about 15, 20 minutes before question period. I think we'll get through most of it. These guys are always worried because I go on and on and on, but I promise I'll be good. I'll be good today. I want to talk about limitations and terms to consider in a power of attorney. And I guess that really what I wanted to talk about here is a couple of matters. One of them is that a power of attorney obviously must act in your best interest to maximize your estate. So your power of attorney, especially your financial care powers of attorney, number one job is to manage your affairs in a prudent manner to maximize your estate. The standard of care of a power of attorney is not perfection. It's to do what a reasonable person would do for you. There's a couple of things you might want to think about in your power of attorney. You'll see the first one says, the power of attorney cannot make testamentary dispositions. There's a section of the Substitute Decisions Act, Section 7, that says power of attorney can basically do anything for your finances except make a will. And make a will isn't defined in that act, but it's defined somewhere else to include making testamentary dispositions. That means your power of attorney can't do things like change the beneficiaries of your RIF or your RSP. So if your RSP leaves your RSP to your estate, your power of attorney can't change that. So it really behooves you to make sure that the forward planning on those documents is done before you make a power of attorney. That doesn't mean a power of attorney can't do anything. They can gift money to other people. So Section 37 of the Powers of Attorney Act allows a power of attorney to gift money to supportive friends or family, or to a limited extent to charities. Now, if you want your power of attorney to be able to gift funds to other people, let's say you're saying, you know what, for estate planning purposes, it's really important that money can leave my estate earlier, so I say probate, or you're saying, I just want to make sure my family can enjoy my money while I'm alive. If I'm one of those people who's going to live to 130, then it's really important that you consider whether you want to put some direction in your power of attorney about when and how your power of attorney can gift. Because if your power of attorney decides, you know what, I'm going to gift money to a whole bunch of people, the first thing the power of attorney has to do is make sure that you have sufficient assets to keep you comfortable for the rest of your life. And two, they have to look at what does the power of attorney say. If the power of attorney is silent, the power of attorney must see if there is a history of giving similar types of gifts during your life. And if there isn't that history, then the power of attorney has no authority to make that gift. So again, if you see that as important, you want to address it in your power of attorney. And I'll give you an example, and it's the Jacobs case. What happened in the Jacobs case was a woman named her daughter. She had 4 daughters, but she named her oldest daughter as her power of attorney. After her daughter began acting, in fact, 2 weeks after she began acting, she made 2 gifts on her mother's behalf. She gave herself $24,000 as a gift. Nothing says a power of attorney can't gift to themselves, as long as there's that history or authority in the power of attorney. Gave herself $24,000 as a little present for graduating from university. The woman had been at university for a series of years, and she said, I know my mother would like to help me. She then gifted herself $34,000 from her mother, and the $34,000 was to be used to buy an RESP for the power of attorney's daughter, the incompetent woman's granddaughter. These were questioned by the rest of the family, and they sued. And the court said, well, we have to look at what the history was prior to the person becoming incompetent, because the power of attorney itself doesn't give us any instructions. So they said, with respect to the $24,000, yep, she often gave gifts to her children, never one this big, but she often gave gifts to her children, so we think that's fine. The $34,000 for that registered education savings plan, this woman never gave gifts for her children, her grandchildren's education, so therefore that one's void and the money has to come back. So again, you have to look at things like that. Not that it much matters to you, but there are other things a power of attorney can do. They can open a joint bank account and transfer funds into that joint bank account. They can, there's limited authority to do estate freezes, which could take an entire day to talk about. And those are some of the things that they can do on your behalf. What I'd like to talk about is the duties of a power of attorney. So what is it a power of attorney can and can't do, or what is it that they have to legally do? Well, there's a list of them, and I'll read it to you. They have to manage properly, consistent with the personal care of needs. So your financial care power of attorney and your personal care power of attorney are going to have to act together, because your financial care power of attorney has to manage your property with respect in a way that meets the needs of the personal care power of attorney's plan. They have to explain to the incapable person the duties and powers that they are using. To the extent possible, you have to keep the incompetent person in the loop. So when I had my conversation with my son to talk about when I become, when and if he ever becomes my active power of attorney, part of the conversation was to make sure he understood that he still had a duty to include me, to take me to the meetings with a financial advisor to the extent possible. Clearly, at some point, there won't be any purpose to it whatsoever, but to keep me in the loop as much as possible. He also has a duty to encourage me to take part in decisions. And if the court deems that he could have kept me in, that I could have been involved in a decision involving my finances, and he doesn't include me, there are repercussions. Those decisions could be void. And I'll tell you a story. And the story I'm going to tell you is the McMillan case. And what happened in the McMillan case was this. Mr. McMillan was 86 years old and his wife died. And he became completely lost. They'd been married forever, and she was everything to him. He became very, very dependent on his 3 daughters and his 3 sons-in-laws. 2 of his sons-in-laws were financial advisors. And he talked to them and he said, you know what, my number one worry is that I won't be able to stay in my condo for the rest of my life. He didn't have a lot of money. I think he had $15,000 in some sort of bank account somewhere. He got a pension and he got some benefits from the government. And that was really about it. The senior supplement was the benefit. The 2 financial advisors, his sons-in-law, did a little bit of a plan, and they said, you know what, if you live conservatively and everything goes well, we think you can probably stay in your condo for the rest of your life. In June, his wife had died in February, Mr. McMillan went to Hawaii on a vacation. And there he met a woman named Elsa. Elsa was in her 40s. She was 42 years old. Remember, he was 86. And immediately his life changed tremendously. When he got back, he became very private from his family. He didn't want them knowing what he was doing. He became visibly upset if he didn't get to speak to Elsa every single day. They had become quite the couple. One night, his daughter, Cindy, the oldest girl, she started looking through his desk because she was really worried about what was going on. And what she found scared her. She found her father had started, all the cash, the $15,000 was gone. He started applying for credit cards, and there was a series of credit cards that had been maxed out. He found out that some of the money had gone, I think it was $45,000, had gone directly to Elsa to help her buy a condo. He found that $35,000 had gone to Elsa to help her start a reggae band that she was thinking of starting up. He found that there was an application to put a line of credit on the condo. He also found, or she also found, that there was a series of photographs he bought off the internet, which were completely useless. He bought them for Elsa, but she had told him that he could probably sell them for a lot of money. The girls became very worried about their dad. They talked to their father. He said it's none of their business. They complained to the police. They complained to, elder abuse agencies, everyone you can think of. No one really did anything. So they went to see their lawyer. And the lawyer said, well, your power of attorney, why don't you transfer his condo into joint name with yourselves? You can do that. And that way he won't be able to mortgage it. He won't be able to put a line of credit on it. He won't be able to sell it without your signed permission, and at least preserves that one document. Long story short, that's what they did. They actually put their husband and father on as joint property owners, but it doesn't really matter, to try and preserve Mr. McMillan's assets. Well, they didn't include him in that decision. Remember, the duty we're talking about is encourage incompetent participation in decisions. They didn't do that. Mr. McMillan found out what they did, and he sued, and he won. The court said, you did this for all the altruistic right reasons, but you've breached one of your fundamental duties as power of attorney. That's to keep him in the loop, to keep him involved in decisions to the extent possible. He should have been in that meeting with the lawyer. And therefore, everything you've done, although it was done for the right reason, is null and void, and everything goes back to him. The courts take that duty very, very seriously. Powers of attorney also have a duty to consult the incapable person's family and friends and other attorneys. There was a case called Sitco, where a power of attorney, financial power of attorney, transferred funds to his own bank account for a whole bunch of reasons we don't have to get into. But he didn't tell his sister, who was the personal care power of attorney. And the court said, you've breached a fundamental duty. You can't ignore supportive family and friends. You have to keep them in the loop of what's going on. A power of attorney also has a duty to foster personal contact with supportive family members. Your power of attorney can't cloister you away. They have a duty to keep other family members at least able to access you if they want to. And again, there was a case called Zhang on that, where a gentleman was not able to see his wife for 2 years because his mother-in-law, who didn't like him, was the power of attorney. He eventually got a court order. So those are some of the duties. And I think the main thing I want to mention here is to do what's in your best interest, but to keep you involved to the extent possible, and to keep other family members involved to the extent possible. I think you'll save yourself a lot of hassle if your power of attorney understands that. The other thing I wanted to talk to you about for a few minutes is the penalties and liabilities of power of attorney. So power of attorney both has civil and criminal liability, potential civil and criminal liability. A personal care power of attorney can be sued if they show the lack of due regard to the health of the individual. That's called elder abuse. And a power of attorney must exercise his or her powers and duties diligently in good faith. And if you breach those duties, you can be sued. Financial care powers of attorney are fiduciaries. They have a duty to do what's in your best interest and act honestly, with integrity, and in good faith. So if those are breached, there's a civil action. Someone on your behalf can take action against the power of attorney. Quite often, you're not going to see an awful lot of money change hands, but you will see the court involved in certain ways. There was a case called Chu and Chan a few years ago. What happened in that case was there was a 98-year-old woman, and she lived with her son, Kin. Kin and one of her grandsons were named as personal care and financial care power of attorney. It was a very sad document because the elderly lady had written in her own handwriting at the bottom of the power of attorney that she's happy when her children spend time with her and when they get along. I wish they'd read that sentence, because they didn't. They didn't get along, and they didn't make her particularly happy. They began to use her and isolate other family members from her. Eventually, in fact, one of the grandsons moved her to another residence, refused to let anyone contact her or even see her. There had been a huge family fight. The court removed that individual as the power of attorney and awarded $53,000 in costs against him, payable to his mother. So again, the courts are looking at that very, very seriously. The other aspect that you have to remember is a power of attorney can be sentenced with criminal charges. A power of attorney can be charged with theft, fraudulently sells property, converts the proceeds of a sale to someone else's use, or does anything else that he's entrusted to do. So there are criminal provisions, and you'll see there that a power of attorney, section 321 deals completely with powers of attorney, can be jailed up to 2 years for theft under $5,000 and up to 10 years for theft over $5,000. And there are countless cases of powers of attorney being charged criminally. And I don't think most of these situations are because you've named evil or horrible powers of attorney. I think quite often it's because you haven't looked at the frailties of the person you've named as power of attorney. I have an acquaintance who's a lawyer, and her client named her son as power of attorney. Unfortunately, her son had a gambling addiction, and she went from being a very, very wealthy woman to a woman who lives in government subsidized housing very, very quickly, because the son more or less took the entire money and gambled it away. Clearly, she could sue her son, or someone could sue her son on her behalf, but there's no money. The money's all completely gone. So it's an incredibly sad situation. But I think usually those are the situations you're seeing, but not all of them. Some of them are very much that the power of attorney that you've named is someone who perhaps you should have spent a little longer thinking about. In R and Hoyer, I'll just give you one example, or maybe two, depending on our time. There was a woman named Flora and her husband, Paul. Flora died, leaving Paul by himself. Paul had dementia, and it was time to implement his powers of attorney. They didn't have any children, but they'd named the next door neighbor's son, Daniel, as their power of attorney. He'd been the kid who did chores for them, mowed their lawn and that sort of thing during his childhood. Daniel, the power of attorney, moved Paul to a nursing home, and then he started to act under the power of attorney. He transferred $305,000 to his own name. He moved into the home, and he stopped paying Paul's bill at the nursing home. So as a result, Paul had to be moved to a government subsidized situation. Mr. Hoyer was charged with theft, and he was sentenced to 2 years less a day in jail in order to repay the $305,000. So occasionally it does indeed happen. And the last thing I wanted to mention to you really quickly before we move to question period, I'm trying to save some time for questions, is compensation. What can a power of attorney be paid? Well, if you're a financial care power of attorney, so the person managing the finances, there's a regulation, and the regulation sets out some percentages the power of attorney can be paid. That's not mandatory on behalf of the court. The court will, if it ever goes to court, look at those things and say, that's the starting point. 3/5 of 1% of the annual average value of all assets, plus those income receipts and disbursements. But they can increase or decrease compensation. And they have to look at 5 factors. 1, the size of the estate, the magnitude of the estate. 2, the care, the responsibilities, and risks taken on by the power of attorney. Was there a whole bunch of really strange properties that had to be managed? The time spent, the skill required, and the result. What was the end result? And based on those factors, the court can increase and decrease from these. But you know what's a lot easier? It's a lot easier to talk to your power of attorney and come to some understanding today about what you think they might be entitled to. Quite often that's put right in the power of attorney document saying, my power of attorney will be entitled to whatever you think is fair and your power of attorney thinks is fair. Because that will save an awful lot of fighting on behalf of your family. A personal care power of attorney, there's no regulations to assist you whatsoever. So a personal care power of attorney, their compensation will be completely based on what you contract or agree to during your life, or will be based on time spent and a fair rate that the court feels should be imposed. So with that, I guess my conclusion for today is that a power of attorney should not be seen as an afterthought. And it's not just a form that you fill out. If you're given a power of attorney that's like half a page long, think again. Does it have anything about when the power of attorney will become effective? Does it have things about how your power of attorney can resign and name someone else as your power of attorney? Does it have anything about whether your power of attorney can gift for you? Does it have anything about the fees that they have to put in place? There's an awful lot of information that can be in a power of attorney, and it's all there to provide you the proper support you need when you need that support. And with that, I'll throw it back to Erik, Jeff, and Per.
Thanks, Keith. So just before we get into the Q&A, I'm going to go through very quickly what our upcoming events are in the new year, and then we're going to go into the Q&A. I think Erik's got the first question for us. Coming up in the new year, so this is our last webinar for the year. Thanks everybody for joining us. Coming up in the new year, we kick it off with a year in review on the markets, followed by we're going to talk about in early February. Everybody usually thinks about RSPs versus TFSAs versus mortgages. We're going to have another repeat performance by Sarah Meinhout from North Star HR Solutions on small business HR questions. And then very popular last year was our Ask Me Anything About Taxes. So we'll do that again in the first week of March. So there'll be emails and invites and social media posts that you guys can see about that as well. So while Erik asks the first question, we'll let this disclaimer sit up here. We're supposed to leave it up here for 30 seconds, I'm told. So please enjoy this. And Erik, why don't you go ahead with the first question you had there?
Sounds great. First off, thanks, Keith. That was a very insightful presentation. I hope that everybody took a few nuggets of wisdom from it. So a question comes from one of our participants, and it asks if our POAs are properly written and state continuing POAs, then in that case, the POA can effectively sign on the client's behalf from that point forward. So no issue there. Now, what about in the scenario if a parent with impaired faculties tries to override the instructions anyways? Any guidance or thoughts on that, Keith?
That's a really hard one. And we see that situation all the time where the child is acting on behalf of the individual, and the individual still has sufficient capacity to try and do something. It's a tough situation. I think that legally, and Erik, you might know, I know you're a lawyer too. I think legally, though, the principal has the ultimate authority to make a decision so long as they have capacity. I think that if that's the situation, you might want to get an assessment done of the principal to determine whether they have capacity or not. Otherwise, I think the principal has the authority to make that decision and override the power of attorney. And of course, if that's not the case, the individual can always revoke the power of attorney anyway, as long as they have capacity. So I think in that situation, I would go out and get a formal appraisal done, assessment done, to make sure the person had capacity. But other than that, the individual has the ability to reverse.
Thanks,
Yeah, it's a tough situation because you can't really force someone to get an assessment if they don't want to, right?
No, it's a tough situation, and you might have to call in the Mental Health Act, get a certificate of the Mental Health Act.
So, hey, Erik, if I can ask Keith a question or sort of define a little more detail around that subject, because it seems, is that okay? Do I have a second here?
No, lots of time. Please go.
Okay. Anyway, so Keith, it seems that whenever we do these presentations, we're looking for clarity, and we end up almost with questions and answers. And I mean, I must say that in our experience, in the 20 some odd years that we've been acting on our clients' behalf and with powers of attorney, we really have not come into any issues with children as powers of attorney, and ultimately taking over the financial decisions of their aging parents or family members, where they're getting challenged. So it seems to be somewhat uncommon when people take care in who they choose as their power of attorney. That said, is it possible in your document of continuing powers of attorney, or even to have a clause that says, you will become powers of attorney when, our family doctor or a doctor and 3 family members together determine that I've lost capacity for my financial affairs kind of thing, rather than have to go through a government agency?
For sure. First of all, I agree with you that most people's power of attorneys, most situations don't blow up into being horrible, horrible battles. I've often said that the difference between me and you is that I live in the 2% of the world that blows up being a lawyer, and you live in the 98% that don't.
Right.
Being a financial advisor. So there's that aspect of it. For sure, you can have any clause. In fact, when we talked about triggering events, if you're going to have a clause in it that says my power of attorney will only become effective if certain things happen, that's certainly available, and you can certainly put that clause in, and then you should have a way underneath that to have the triggering event, to know that the triggering event occurred. So for sure you can do that. The other thing you might want to consider, and you're seeing it more and more in powers of attorney, is a clause directing that your power of attorney become educative. It's kind of interesting the number of powers of attorney we're saying where the power of attorney is mandated to meet with the financial advisor and go through what the financial advisor's role is, to meet with the lawyer and talk to the lawyer about what legally the power of attorney can and can't do. And all of these clauses, there's only one purpose to any of them, and that is to make sure that your family is left a peaceful roadmap and you're well looked after. And so I think more of those types of clauses is a great idea.
Okay, so I've got to steal the conversation again for one other thing. And so, you know, for instance, in our practice, we have been working with our clients for maybe 20 plus years, and they're financially, they're invested in a prudent way, in a way that they can sustain their lifestyle, and in a way that there's inheritance generally for their offspring. You know, is it prudent to have some restrictions in that power of attorney on what they can invest in and when? Because not only are they investing for the aging parent, but they're also investing for the ultimate inheritors, the rest of the beneficiaries of that estate down the road.
Yeah.
And to prevent some, hot young power of attorney from saying, from being a hero and investing in something really speculative, for instance.
Yeah, first of all, power of attorney has a duty to there's tons of stuff about power of attorney's limitations from an investment point of view, and making sure that the power of attorneys invests according to the KYC document, the Know Your Client documentation of the elderly individual or the person under whom duty they have. So probably they're in breach if they do that sort of thing anyway. But I think it always makes sense to have some clause saying, in acting as my power of attorney, I have always invested in a conservative manner, and I hereby instruct my power of attorney to continue following that. It at least gives them some direction. I mean, in law, they're sort of limited to that anyway because of the duty to watch their own KYC documents.
Okay, so when you name a continuing power of attorney, in essence, they become your power of attorney from that point, the point the document is signed, whether you have your capacity or you don't. But as a person giving power of attorney, you always have the right to override because you have your faculties, right? And it only becomes, in essence, effective when you decide that you don't want to override the power of attorney that you've given.
Yeah.
Okay. Thanks.
I mean, there's a lot of reasons why people don't want to put a triggering event in their power of attorney. And again, it comes down to that 98% and 2% thing, but it simplifies things a great deal. If you have a great relationship with your power of attorney and they know that this is only to be enacted, under certain circumstances, and you don't have those conditions in it, even though it becomes effective immediately, it comes down to trust of your power of attorney, and it makes it a lot simpler because there aren't all those conditions in effect. Yeah.
Gotcha. Okay, thanks.
No problem.
Another question here for you, Keith. A client is asking if they can make their daughter, who is a Canadian citizen but is living abroad in Ireland, as their power of attorney. And then what about her future husband? He's an Irish citizen. Can he be also a backup power of attorney, for example?
There's absolutely no legal reason why your power of attorney cannot be a non-resident of Canada, or even has to be a citizen of Canada. As I said before, the issue from a legal point of view would be the situs of you for tax purposes, because you don't want to find yourself migrating to another tax jurisdiction. But because the power of attorney is only an agent, there is no effect from a tax perspective. Where they will have an effect is in dealing with your financial advisor, because your financial advisor will say, I can't take instructions from you anymore. The financial advisor will not have a principal, and therefore they won't be able to instruct on selling and buying. But other than that, from a legal point of view, you can certainly name one.
That's really helpful. I think we'll take one last question, and then we've kind of hit our 1 hour mark, and that's great. So it's been a lot of great discussion, great information. So Keith, I want to thank you for that. One other question we had here is, what can invalidate a power of attorney?
Well, that's an interesting question. I guess power of attorney is like any contract. If it doesn't have, if it was entered with undue influence or duress, or you entered it when you didn't have capacity, it's going to be a void document. But really, you have the freedom to name your power of attorney, and as long as you're free from undue influence and duress, and have capacity when you sign it, very little can invalidate it. Families can go to court, and maybe that's the other half of the question, to try and remove the power of attorney and name someone else's power of attorney, if they believe the power of attorney has flagrantly, and I add that word on purpose, flagrantly, flagrantly abused those duties that we talked about, the duties to make sure that they look after things for your needs, maximize your estate, and make sure that they have that sort of cooperative regime that we talked about.
Okay, so yeah, so just as long as we're careful, power of attorney can continue. That's good.
Right. So just to be clear, in the case of a client with a Canadian citizen living abroad becoming power of attorney, would that Canadian citizen still have the ability to sign on their behalf with a Canadian financial institution, or do they have to be a Canadian resident?
I understand most of MFDA and IROC's recommendations, rules are, and you might know better than me, is that your principal has to be a Canadian resident, not citizen. Okay. So I think that if they're not a resident, you have a problem to take instructions. Okay.
There are conditions under which we can have clients who, so Americans is a big no-go for us. There are conditions in which we can have conditions that are not American and not resident in Canada. But it's complex, and the answer is it depends.
Yeah. So in those cases, it would be beneficial to have your power of attorney have the right to name a contingent.
Yeah, exactly.
In the case that, for instance, say they move out of the country for 2 years, and there's a zillion circumstances where that might be prudent. Okay.
Yeah,
exactly. I think that's
or something. Yeah.
I think it's a good point. I think it's prudent to have that clause in it, and I also think it raises another point, and that is that before a power of attorney is signed, it's not a bad idea to talk to your financial advisor and say, this is what I'm thinking of doing. Do you see any problems going down the road? Because the whole purpose of this document is to make sure that you have that continuation of service from your group of advisors.
Yeah.
Agreed.
Thanks. Well, Keith, on behalf of the WWH Financial Group team and Asante Wealth Management, we wanted to thank you for presenting to us today. We're getting a lot of nice feedback in the chat there about your excellent presentation. As usual, very informative, a little bit funny, and a lot to chew on. So for anybody that attended and anybody that didn't attend, we will be sending you a recording of this webinar so you can watch it again and catch any bits that you feel that you missed or want to brush up on. And again, Keith, thank you so much. And everybody keep an eye out for our emails and social media posts about our upcoming webinars in the new year. And in the meantime, have a great start to November. Thank you, everybody.
Thanks, guys. Good seeing you again. Bye-bye.
Thanks, everybody.
Bye-bye.